Welcome and thanks for taking the time to join us today. I'm Charlie Imbergamo, the Director of Strategic Programs at the Nonprofit Leadership Center. Our NLC team has continued our commitment to develop and connect leaders across the region to strengthen organizations and our communities. We believe that knowledge gained and shared strengthens all of our leadership. It's an honor for us to welcome you into this virtual space for today's webinar, Reopening, Best Practices to Minimize the Spread of COVID-19 and Your Organization's Liability. As the weeks of challenge related to COVID-19, the pandemic, social unrest, economic hardship, and the ongoing balancing of work, self-care, and home life has continued, our thoughts always turn to you and your organizations and how we might be able to support you. To recognize and celebrate you and the organizations you represent, I'd ask you to locate the chat box at this time and to type the name of your organization into the chat right now. And as we see the names of your organizations stream through the feed, take a moment to recognize the power for good in the community through the work that you are all doing. Let that sink in for a moment. And on behalf of those we serve, thank you for that work. We're joined today by Karen Busing. Karen's a partner at Ackerman LLP in the Tampa office. She has more than 35 years of experience counseling and representing management in all matters of workforce law. Karen is one of approximately 200 lawyers who are board certified by the Florida Bar as a specialist in labor and employment law. Her expertise includes representing employers in discrimination and harassment, hiring, firing, disciplinary matters, non-compete, trade secret litigation, whistleblower, retaliation claims, and really all aspects of employment counseling and training. Needless to say, she's eminently qualified to lead this discussion with us today. She's currently on Ackerman's Return to Work Resource Guide team, assisting employers in navigating reopening during COVID. So that support will really help each of us today. We're grateful that Karen reached out to us to offer her expertise on this topic, and we welcome her participation with us. Moderating our session today is my teammate, Karina Kletter, NLC's program associate. Karina has been instrumental in standing up this webinar work and all of our virtual work that we've done. We simply couldn't do it without her expertise, her know-how, and her commitment. She'll take us through some of the rules of the road for our time together today. Karina.
Thank you, Charlie. So just a few quick logistics for the webinar. To minimize background noise and distractions, all lines will be muted for the duration of the webinar. This session is being recorded and will be available on our website for future viewing. We warmly welcome your questions. Please go ahead and type them in the chat box as they arise during the webinar. Karen will try to take the immediately relevant questions as they come up, and we'll also take some time at the end of the presentation for any last questions that haven't been addressed. If you haven't found the chat box yet, go to the settings at the bottom of your Zoom screen and click on chat. We're so delighted to have Karen with us today and look forward to a great informative webinar. On to you, Karen.
Thank you very much. I appreciate having the opportunity to talk with all of you today. And I am going to pop up my share screen and start my presentation so we can see it. So hopefully everybody can see that. As Charlie said, we're going to talk about best practices for minimizing the spread of COVID-19 and liability for your organizations. So thank you again for letting me speak with you today. The first thing I want to emphasize, and I'm not advancing here. Okay, the first thing I want to talk about is the mitigating risk and exposure proposition. I think that probably everyone has seen the headlines. This is one from this week. The Wall Street Journal had this very sad story about these many families that have begun filing the first wave of COVID-19 lawsuits over worker deaths. related to reopening workplaces. Walmart, Safeway, Tyson Foods, a number of healthcare facilities have been sued for gross negligence or wrongful death. In addition, McDonald's and a number of other companies have been sued on other theories like nuisance. This is going to be a real stretch for businesses as they reopen, and for nonprofit organizations as they seek to continue to serve the people that they serve. And I know there's a broad variety of you and what the kinds of things that you do. So the wave of COVID-19 litigation asserting claims includes not just what I just talked about, the failure to provide a safe workplace where there were inadequate protocols or PPE or protection from customers who came into the workplace, but also internally discrimination claims, particularly by older workers or workers with disabilities. There have been claims relating to failure to provide sick leave or family and medical leave for reasons related to COVID-19 under the Families First Coronavirus Response Act, which we'll talk about later in the presentation. There have been retaliation and whistleblower claims where employees are terminated for complaining about workplace safety or working conditions or for exercising their rights. Now, with respect to the employee claims, you might think, well, workers' compensation will take care of that. And ordinarily that is the case. Under workers' compensation laws, most employers are not subject to lawsuits because employees can't sue their employer in court for injuries or illnesses that they sustain at work. That's the purpose of workers' compensation, and it's set up that way on purpose so the employee doesn't have to prove the employer was at fault in order to collect workers' compensation benefits for their bills and a portion of their lost wages. But generally, they're not permitted to file suits against their employer outside of workers' compensation, except in narrow circumstances. For example, if the employer shows a complete disregard for the worker's safety or acts in a way that would amount to reckless or intentional misconduct. And that's the nature of the kinds of claims that we're seeing today. So you've got to be very, very careful about that. Understand that all employers have a duty under the Occupational Safety and Health Act to provide a safe workplace. That is, a workplace that's safe from recognized hazards that are likely to cause serious injury or harm. So while workers' compensation should cover claims relating to workplace injuries and illnesses, if a lawyer for a plaintiff can establish that the employer was reckless or engaged in intentional conduct that resulted in that illness or injury, then there is exposure. So what's the best practice to avoid those kinds of claims? First and foremost, it's to demonstrate compliance with federal, state, and local guidance and orders. And that is not as easy as it sounds. There is also a whole separate area of claims, not just worker claims, but customer claims. So in general, businesses owe a general duty to customers to protect them again from foreseeable harm. There are some exceptions to that. So there's no duty to somebody with whom you don't have a relationship. But there are certain businesses like airlines and railroads and taxi services that have a greater obligation. But in general, it has to be reasonable to believe that the harm would result from the business's failure to act for there to be any kind of liability. So what are the lawyers looking at now? They're looking at, did the business have a reasonable opportunity to warn people of the harm or take action to protect the customers or visitors? And then once a duty of care is established, did the business breach that duty? And if so, was that breach the cause of the person's injuries? What, for example, in the context of COVID-19, is the obligation of a business to warn of past exposures to COVID-19 at the workplace or to protect present or future employees or customers or visitors from exposure? So again, I want to emphasize that the best thing you can do is to comply with CDC and OSHA guidance. So everybody's familiar by now with the Centers for Disease Control. We're hearing from them, or they are in the news, even if we aren't hearing directly from them anymore, daily. Back in May, the CDC said that all employers should implement and update as necessary a COVID-19 plan. That is a plan that is specific to your workplace, that identifies all areas and job tasks with potential exposures to COVID-19, and includes control measures to eliminate or reduce such exposures. So a plan should identify ways to prevent and reduce transmission among employees and, in theory, customers or visitors to your site, maintain healthy business operations, and maintain a healthy work environment. So that's back in May. The CDC, since that time, has issued very specific guidance for multiple industries and sites. Those would include, and this is not a comprehensive list, but all of those on the screen right now: restaurants, bars, casino and gaming places, small businesses, schools and childcare centers, colleges, universities, parks and recreational facilities, community and faith-based organizations. All of these, there is specific guidance on the CDC website for each of them. And I mean, it is very specific. This is just a sample page from the CDC website of some of the things that they recommend that a business does. In addition, keep in mind that OSHA also issued guidance on preparing workplaces for COVID-19 and for reopening back in March, and then again in June. So back in March, OSHA said if you don't already have an infectious disease preparedness and response plan, you need to. And also in June, they issued new guidance, which was much more thorough, relating to reopening, that talked about conducting a hazard assessment for each job category, outlining protective measures, and conducting health screenings. This is what you really need to be paying attention to today. Now, don't be intimidated by some of those terms. So the June 18 OSHA guidance talks about what you should do during all phases of reopening. So during all phases, you should implement strategies that are, again, appropriate for your particular workplace, because what works for an office is not going to be the same thing as works for a church daycare facility. And so you've got to be very, very specific with your particular environment. They want you to do a hazard assessment, which means determining when, where, and how employees might be exposed. So you're supposed to do a hazard assessment for each job position. And then you're supposed to make sure you've got basic hygiene in place, cleaning and disinfection protocols in place. They want to make sure you have social distancing arrangements set up. They want to make sure you have procedures for identification and isolation of sick employees, policies for return after illness and exposure, workplace controls and flexibilities. Those would include things like engineering and administrative controls, safe workplace practices, personal protective equipment. All of those, again, depending on the individual job and the potential exposure risk to COVID-19 there. OSHA also encourages companies, including organizations like yours, to have workplace flexibilities around telework and sick leave. That's not always possible, but they encourage that where it is. And they want to make sure you have got training on the signs, symptoms, and risk factors associated with COVID-19 and how to prevent its spread. And I'm going to go one further and say that training needs to include training on your protocols. And we'll talk a little bit more about that in a minute. And then also OSHA says your plan should include anti-retaliation policies that assure no adverse action is taken against an employee who raises a workplace safety or health concern. So those are basically the elements if you're going to design a COVID-19 plan. The other thing you must keep in mind is those are just the elements from the federal guidance. Again, CDC and OSHA have not issued regulations. The current administration has not permitted that or required it. So it's just guidance. But some local, state and local organizations have done so. So state and local government agencies. And they vary significantly. I was working with some folks in New York, and they had to do a COVID-19 plan, and New York even has a template for the COVID-19 plan that they want you to use with specific things that you have to address. In Miami, I worked with an employer that had an office that was in the city of Miami, and that meant that they had to comply with both the city of Miami emergency order and the Miami-Dade County order. And they had 2 different temperature thresholds for when you have to bar employees from entering your premises, and 2 different requirements for closure when there was an exposure within the office. So you've got to comply with the most restrictive one. So keep in mind that it varies depending on the location, and you may have state or local executive orders or emergency orders, they're called different things, which are much more restrictive than the federal guidance. So in order to prevent the spread of COVID-19 as much as you can, and in order to limit your exposure as much as you can, you've got to be sure you're complying with all of those, federal, state, and local. I'll call them guidance, even though the state and local ones are often orders. So let's talk about putting together a COVID-19 preparedness and response plan. That's just a fancy term that OSHA uses. You can just call it a COVID-19 plan if you want. And again, you can look at that OSHA guidance from June 18 of 2020 and follow along the categories. A couple of things that aren't specifically mentioned that you want to think about. 1, identify a COVID-19 monitor. This is going to be somebody who's going to watch that CDC guidance and keep an eye on it. And when it changes, as it does, make sure that you let people know. So you might remember in the beginning, the CDC said, don't wear a mask, save the masks for healthcare providers. And then the CDC said, everybody should wear a mask. That's what I mean. The guidance can change. So somebody needs to be watching that. And the other role of the COVID-19 monitor in your organization is to be the point person. So if somebody has some kind of a concern about an issue at work relating to workplace safety and COVID-19 exposure, they know who to go to. So you want to identify a monitor and make sure everybody in your organization knows who it is. Number 2, conduct a hazard assessment of each job. Again, that's fancy schmancy phrasing for just take a look and see who's likely to be exposed, where, and how. Then identify safety protocols for each of the people in those roles. So they might be different from one person to the next. Train your employees both on the spread of COVID-19 and on your safety protocols. And then have them acknowledge receipt of the COVID-19 plan and their obligation to report safety issues. That's not in the OSHA guidance, but I think that will help you go a long way if you do get a claim, because if you have people sign an acknowledgement saying, I've read the plan, I understand the plan, I understand that if I have any issues, I'm supposed to report them to the COVID-19 monitor. And then if they don't do that and they try to bring one of these lawsuits against you that you're seeing in the newspaper every day, you're going to be in much better position to defend the potential claim than you otherwise would be. So have people sign an acknowledgement, and do let them know that your COVID-19 plan is going to be a document that's ever evolving, because the guidance keeps on changing. So as you do that, you don't necessarily have to generate a whole new plan every time, but you should communicate with your employees in the manner in which you would ordinarily communicate with them about changes in the plan. So if you change your temperature threshold or your screening questions, the CDC recently changed the recommendations for screening questions, you want to make sure that you've talked about that or shared that with your employees in the manner in which you would ordinarily share that kind of information. Your COVID-19 plan protocol should definitely address all the things that are in the CDC and OSHA guidance, including pre-arrival screening for symptoms. That's my recommendation. Screening for symptoms is recommended by the organizations. My suggestion is that you have people do that before they arrive at the work site for a host of reasons that we can cover. And then strategies for making sure we're keeping what we're calling social distancing, but should really be called physical distancing, I think. And then cleaning and disinfection efforts. We want to make sure that you've got that covered too. All right, we talked for just a minute about sample daily health screening questions. So the OSHA and the CDC both recommend you screen employees. And again, if you're not customer facing, you want to definitely be screening all of your employees. If you are a customer facing organization where you have people visiting your work site day in, day out, and that is the nature of your business, like you're like running a child care center, where you have actual participants in your programs, you're going to have to be even more stringent about your screening. These are sample screening questions that have been updated. You'll note that the symptoms for COVID-19 have changed over time. So this is the latest list of symptoms. So you should ask people, and again, my recommendation is before they come to work, you do this in an email format. You have them self-screen. They take their temperature at home, and do they have a fever of 100.4 or higher? Are they experiencing any of the following symptoms: fever, chills, cough, shortness of breath, etc.? And then in the previous 14 days, have you had any contact with someone who at the time of the contact either had a confirmed diagnosis of COVID-19 or had symptoms and was awaiting test results? In the previous 14 days, have you traveled to a state or international country with widespread sustained community transmission or been on a cruise ship? You notice that some of our states right now are banning people from, one of them bans them from 31 states, including Florida. So some states are very aggressive about this screening. Go back. Yes. Keep in mind that there is a significant confidentiality obligation. So whoever is asking these questions needs to be very sure that they understand that they must maintain the confidentiality of the information that they get. All medical information regarding employees must be maintained in separate confidential medical files, separate from your regular personnel files. And so a lot of times people have an individual who's doing the screening at the site. This is why I say it's better if you have the kind of site that you can do this and workforce that you can do this, if you have people complete their screening assessment at home before they come in and confirm that they can answer no to every question, they don't have a fever of 100.4 or higher, or whatever their local requirement is, and that they can answer no to each of those questions, they haven't been exposed. If they can do that at home and just confirm by email that they have conducted their self-assessment and that by coming into work, they are confirming their answers to all the questions were no, that's fine. There's no reason for you to maintain medical information you don't need, and it's dangerous to do so. If you have somebody screening at your site, you need to be very careful, because whoever's doing the screening must have the right PPE, their protective equipment. You've got to figure out a way to have social distancing for that person, or make sure the protective equipment is going to protect them from getting close enough to, for example, take a temperature. If they're already in your work site, they could already be infecting the work site if they have symptoms. And then what if you turn somebody away in front of other people at your work site? You've effectively given away medical information, or at least they might think you have. So you've got to be very careful about that. Do not maintain medical information you don't need. And if anybody is participating, any of your employees are participating in this, make sure they understand their obligation not to disclose confidential information. That is critical under the Americans with Disabilities Act. You also want to adopt rules for illness. And I had a series of slides about this in here, and I took them out because the CDC keeps changing its guidance on that. But essentially, if you have any employee that displays any sign or symptom related to COVID-19 or any other illness, other than one that they know is unrelated, they should immediately be isolated and removed from the work site. My recommendation is that you don't let people be permitted to return until they meet the appropriate CDC return criteria. Again, that CDC return criteria keeps on changing. One thing you can do is encourage people or require people, as long as you consistently do so, to submit a doctor's note clearing them to return to work. I will tell you that the government agencies don't like it when you do that, but they don't bar employers from doing that. They don't like it because they think there is, doctor's offices are crowded right now, and it's very hard to get a doctor's appointment, or maybe people don't want to get in. So they're concerned about that kind of a thing. And so they say it's a bad idea to require that. Most of my clients are in fact requiring employees to submit doctor's notes clearing them to return to work. Okay, so you've got your plan in place. and you provide it to your employees. You do a little training program. You tell them how COVID-19 spreads. You tell them about your safety protocols and what you've done. And then you have an acknowledgement at the end of it that says, you know, basically, I have read the plan. I understand my obligation to follow the safety protocols and to notify your COVID-19 monitor, whoever that is, of any safety issues or concerns. This is an acknowledgement of the plan and their obligations. It is not a waiver. You do not want to ask employees to sign a waiver because they have rights under the law, and you don't want to interfere with their rights to raise issues about terms and conditions of employment and workers' workplace safety. So again, you're not asking them to waive anything. You're asking them to acknowledge that they've seen the plan, they understand their obligations, and that they're going to notify you if they become aware of any safety issue. Before I move to talking about the kinds of organizations that have participants that might want to consider a waiver and release, do we have any questions about doing a COVID-19 plan?
We've got a couple of questions in the chat regarding the medical questionnaires and keeping files. The question from Josie is, do the questionnaires have to be in individual files per person, or can they be kept by date as long as they are not in the regular personnel file?
My question back to you is, why would you keep the information at all? Unless you are in a jurisdiction that requires you to retain that information, and the only jurisdictions that I have looked at specifically require that you retain information confirming that you have conducted an assessment, not the information yielded by the assessment. You should not be retaining medical information that you do not need. And no, it shouldn't have multiple employees' names on it and be by date. First, I would not recommend you retain that information at all. The only thing you need is to have employees confirm that they have conducted a self-assessment, or that if you're doing it yourself, you need the person who's doing it to confirm that they screened all employees and only those persons who passed the screening were admitted to work that day. There is no reason to retain individual medical information except employees who test positive for COVID-19, and then you need to maintain in a confidential separate file for that employee. And the only reason you need to retain that is because you're going to have to work with the health department on contact tracing. So that person's name will be reported only to the health department in accordance with law, and not to any of the coworkers. You will have to notify coworkers that there has been an exposure in the workplace, but you can't say to whom unless you have the consent of the individual who tested positive.
Josie, does that answer your question, the second question about the lawsuit? Okay, so just two more questions. One is, would you recommend a document that lays out all of the rules for an individual that will be doing the screening?
Yes, you should definitely have a record that you trained that person. So I think that's really, really useful, especially about the confidentiality piece and about maintaining social distancing and wearing protective equipment to the extent they cannot maintain social distancing. Yes, I would definitely recommend that.
Okay, the last question from Mary is, can we require a negative COVID test prior to returning?
Well, that's a complicated inquiry. You can. I'm not sure how much good it does you, though, because you can test on day 3 after exposure and have a negative test, and on day 11, because it's got a 14-day incubation period, you can test positive. So I'm not sure it does you a lot of good to do that. You're better off following the CDC guidance, which has to do with the number of days, depending on whether the person was symptomatic or asymptomatic, or there is an alternative of 2 negative tests 24 hours apart, or just having people submit a doctor's note clearing them to return to work. But there's no law that says you can't require a negative test. It's just that I don't think that's necessarily going to protect you, because somebody can test negative on day 3 and then test positive on day 13. Okay, should I move on? All right, very good. So we've talked a little bit about the plan. Now, if you've got the kind of organization that has participants rather than an internal, like an office kind of workforce. So for example, traditionally we think about skydiving when we think about releases and waivers, but sports camps, fitness centers, the youth child care facilities, these are kinds of places where you're going to have actual participants. And in those circumstances, you might indeed want to consider requiring a participation agreement, waiver, and release. And what that's going to be is, again, you're going to develop a plan. So let me use as an example a child care center, a nonprofit child care center. You're going to have your COVID-19 plan that follows the CDC guidance, which is very specific for child care centers. And you are going to share it with the parents. And you're going to have the parents acknowledge that they can't bring their kids if they have any of these symptoms, that the kids are going to be pre-screened, that if the parents, if there's somebody in the house that's sick, blah, 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 you're going to have them acknowledge all these things that are in the plan. And then they're going to sign an agreement basically saying, I understand that there are risks associated with bringing my child here. And those can include, playground injury and everything else, but they also could specifically include exposure to COVID-19. And I think it's a good idea to have them waive claims and release the owners, operators, and employees from any cause of action arising as a result of participating. They should expressly include a COVID-19 waiver and an acknowledgement of assumption of risk. Again, this is for participants. It is not for employees. You do not want to ask employees to sign waivers. Now, while I'm recommending this, I want to caution you that there is no indication that waivers like that will be enforceable. They simply haven't come down the pike yet. This is all so new. COVID-19 is all so new. Waivers typically have to be knowing and voluntary, and courts scrutinize them very carefully because they don't like people to have to waive their claims. And remember, a waiver will not release an owner, operator, or anybody else from intentional or reckless conduct. So again, best practices, follow the CDC, the OSHA, the state and local guidance. Share your plan with both your employees, and if you have the participation kind of an operation, share it with those folks. I would suggest getting having your parents sign participation agreements and waivers if you're, for example, operating a child care center or a youth camp or something like that. The waiver should be not only claims on behalf of themselves, but also on behalf of their children. They got to sign on behalf of their children. Do something like that. It might help and it might not, but hopefully it will. And if you're following the CDC, OSHA, state and local guidance, hopefully you'll be protected. Okay. Any questions on that one? Otherwise, I'm going to move on to exposure in the workplace.
Yes,
Okay.
we did have a couple of questions.
Okay.
One is, can you have volunteers sign a waiver?
You certainly can. You certainly can. I don't know what kind of volunteers we're talking about, but yes, you do. In fact, I think it's probably a good idea. Again, you want to share your plan with volunteers, make sure they understand the precautions you've put in place. And then that they are volunteering and that they understand that there is a risk of exposure and that they are assuming that risk and that they're not going to sue you. Again, the key is making sure you are taking the steps, you outline the steps to try to protect people and that you're taking those steps. Okay.
I've got a couple of more questions, and one of them seems like it could be related to this very slide. So I'll share it with you and let you address it. Is there guidance about length of employee exposure to another employee who tests positive? I've heard that some companies are informing employees of a positive test result, but then saying that the person was not exposed for 10 to 15 minutes.
Yes, there is guidance on that. It's very simple. The close contact within, that's the term that the CDC uses, was there close contact. Close contact means within 6 feet for 15 or more minutes under current CDC guidance. So if you are within 6 feet for 15 or more minutes of someone who has a positive COVID-19 case, you have potential exposure. And if they have to do contact tracing, those are the people they're going to try to find out about. Were you in a conference room where you were with somebody for more than 15 minutes. Not just did you pass them when you went and got a cup of coffee in the canteen for 2 seconds, so it's 15 or more minutes within 6 feet. Did you have another one, Karina, or should I go on?
Yes, just one more. The question is, why is there a liability risk for COVID-19 but not for the flu? Will this in the future establish that the same will apply for flu season?
Oh, probably not. The flu is transient typically. There are people who do die from the flu, but it is not nearly as deadly or dangerous as this particular virus. If you have people visitors coming to your site for anything, it might be that you want to have a waiver agreement. But the flu doesn't get the same kind of attention that COVID-19 has gotten because you haven't had the same volume of cases and the critical long-term damaging problems that many people who are exposed to this virus have. So. Okay, let's talk about exposures. If you have an employee who has COVID-19 symptoms, again, you want to direct them not to come to work. Hopefully you pre-screened them at home or got them before they got inside the work site and exposed anybody for 15 minutes or more within 6 feet. Again, and here it is, employees should be instructed if they had close contact within 6 feet for 15 minutes or more with anybody who at that time of the contact had a confirmed case or had symptoms and was awaiting test results, they should call their doctor. Don't have them report to work. Employees should be permitted to return to work only when they meet the CDC return to work criteria, or provide a doctor's note clearing them to return to work. And again, the CDC return to work criteria depends on whether the person who had COVID-19 was symptomatic or asymptomatic. But in general, you should sort of keep in mind that this virus has an incubation period of about 14 days and that people are contagious about 48 hours before the onset of symptoms if they have symptoms. And so what the general guidance has been is to self-isolate and monitor yourself for 14 days. So that is the general guidance. Now, obviously what happens is when people get symptoms, they leave the workplace or they figure it out and then they're gone for a few days. And typically we're waiting in this area, there's about 5 days until you get a test result. And so hopefully they've been out of work for 5 days. So then you're just looking at the difference between when they had the onset of those symptoms and the 14-day window that you have to worry about. But again, this keeps changing. So go to the CDC website and look at COVID-19 exposure, and it talks about whether they're symptomatic or asymptomatic, hospitalized or not hospitalized, and then the return to work criteria for that. Keep in mind that you will have to report positive test results to local health authorities. And under no circumstances should you disclose the name of the positive individual to anyone other than health authorities unless the individual consents in writing. Now, I will tell you that many, many people are willing to consent in writing because it's their fellow workers and they care about them and they want them to know that they were exposed. And so many folks will, in fact, be happy to share their information and say, yes, you may tell my coworkers. I've known people who, well, I was in a conference room with these people for 4 hours. This is before all of the social distancing. And so they were exposed. Yes, tell them who it was. But don't do that unless that individual consents. And I would recommend you get that consent in writing. Again, if an employee tests positive for COVID-19, let's say you operate a child care center, you want to determine who's had close contact with that confirmed positive employee in the time period commencing 48 hours before the onset of symptoms. You've got to direct those, or you should direct those who had close contact with the confirmed positive employee to self-quarantine for 14 days from the date of the last close contact with that employee, self-monitor, or follow the latest guidance. This was current as of last night, I looked, just to be sure. So that was as of last night. But again, there are different standards for returning to work depending on the symptoms, no symptoms, hospitalization, et cetera. I've mentioned this a couple of times already. I'll say it again. An employer may want to require employees to submit a doctor's note confirming the employee does not have COVID-19 and releasing the employee to return to work in writing. But The agencies don't like you to require it because doctors' offices may be overwhelmed. I think a lot of people are not going to doctors' offices unless they have a critical need, so that may turn out to be not the issue. But again, would not allow employees to return to work until either they meet the CDC return to work criteria, or a doctor confirms that the cause of their symptoms is not COVID-19 and releases them to return to work in writing. Okay, anything else on that before I jump ahead to the Families First Coronavirus Response Act? I want to make sure we have time to cover this because I'm sure you all have some questions about it. Okay, I'm going to jump ahead. Okay, everybody heard about this when it passed. Effective April 1, employers who are private employers with fewer than 500 employees, including nonprofits, and certain government employers, they are required to provide paid leave to eligible employees. There are two kinds. One is emergency paid sick leave. One is expanded family and medical leave. But the important thing for many nonprofits is that small businesses with fewer than 50 employees may qualify for an exemption from the requirement to provide leave, but only because of one circumstance. Emergency paid sick leave, there are 6 different circumstances in which an employee is entitled to it. Under the expanded family and medical leave section of the Act, there is just the one. And I'm going to refer to it as school closing or childcare unavailability. That's really a shorthand way of saying it. But essentially, a small business with fewer than 500 employees may qualify for exemption from the requirement to provide leave due to school closings or childcare unavailability if the leave requirements would jeopardize the viability of the business as a going concern. So you still have to provide leave under the emergency paid sick leave for the other 5 reasons, but you would be off the hook under the expanded family and medical leave or for the reason of loss of childcare under the emergency paid sick leave. Okay, let's talk about the first bucket. So the emergency paid sick leave section says you've got to give up to 80 hours of emergency paid sick leave at the employee's regular rate of pay where the employee is unable to work or telework because, and there are 6 reasons, really only 5, but essentially the employee is subject to a federal, state, or local quarantine or isolation order. These do include the local ones. So if you have a local order that says you're required to close your business for 24 hours to clean it after a positive exposure, that would be such an order. Second, if the employee has been advised to self-quarantine by a healthcare provider due to concerns related to COVID-19. Third, the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. Fourth, the employee is caring for an individual who's subject to either the quarantine or isolation order or sick. The employee is caring for son or daughter if the school or place of childcare has been closed or the childcare provider is unavailable due to COVID-19 precautions, or number 6, which doesn't exist. There is no such thing. So I want you to note that there is nothing in here that requires you to pay emergency paid sick leave to somebody who chooses to go to Myrtle Beach for a long weekend. You can tell that person that they need to self-quarantine for 14 days unless they are advised to do so by a healthcare provider because they might have COVID-19 or they're experiencing symptoms and seeking a diagnosis. You don't have to pay them for that. And so that's something you might want to keep in mind in drafting your policies. You want to discourage people from putting themselves in exposed situations where they might get this virus. And one way to do is to make sure that they understand you don't have to pay them if they do that and they don't meet one of these criteria. Okay, all employees of covered employers are eligible for 2 weeks of this kind of sick leave for the reasons related to COVID-19. Part-time employees are also entitled to it, but it's based on the number of hours they would ordinarily work. This kind of leave is in addition to any other leave entitlements that the employer regularly offers. The expanded FMLA leave only covers employees who've been there at least 30 calendar days. That restriction doesn't exist for the paid sick leave, just for the FMLA. And those employees are entitled to an additional 10 weeks of paid expanded FMLA leave at 2/3 their regular rate of pay. Again, if they're unable to work or telework due to a bona fide need for leave to care for a child whose school or child care provider is closed or unavailable for reasons related to COVID-19. And the employee must provide notice of the need for leave as soon as practical. Now, the small business exemption, again, if you've got fewer than 50 employees, you might be exempt from providing the emergency paid sick leave, but only due to the school or daycare closure situation. And you would be exempt or might be exempt from the expanded FMLA leave, again, only due to school or daycare closures for COVID-19 reasons, if doing so would jeopardize the validity of the small business as a going concern. So what does that mean? You would have to be able to show that providing leave for school or childcare closure or childcare unavailability would threaten the company in one of these three ways. Number one, the leave would result in expenses exceeding available revenues, causing the business to cease operating. Number two, the absence of the particular employee requesting the leave would entail a substantial risk to the capabilities of the operations because of the employee's unique skills or responsibilities. They're the only person who do that, for example. Or there would not be enough other qualified workers available to perform the work needed to keep operating. So let me go back to the child care center. There's a classic example. You have government ratios. You must maintain a certain number of teachers to students. You can't let the teacher take leave if it would reduce your ratio and you don't have someone else available to cover the work. So those are the kinds of examples. You have to determine whether you're entitled to this exemption with respect to the specific employee requesting the leave. You don't just say, okay, I have fewer than 50 employees, I'm claiming that exemption. Again, you can deny it where you can show it would cause your expenses and financial obligations to exceed your revenue, pose a substantial risk to your ability to operate, or prevent you from operating at your minimum capacity. And all you have to do is have an officer make the determination, document which reason it is and why, and then maintain that information in your company's records. Okay, I'm not going to cover these last three slides. We had a couple of questions ahead of time about air filtration. And so I plugged these in here for the person who was interested in that question. At the very end, you will see a link to the website that talks about the air filtration guidance. This is just a little excerpt. These last three slides are a little excerpt. Okay, do we have questions on the FFCRA piece?
Yes, we did have a couple of questions come in. One of them from Michael was about the family leave and asked, what about parents who elect to keep their children home from school if given a choice by their school district?
Yeah, so the Department of Labor has not yet spoken on this. Here is my instinct. If you have a parent whose child has a medical condition which would make them particularly susceptible to COVID-19, then I think you have to evaluate this situation differently. But let's go back to those slides. So again, it's the school or child care provider is closed or unavailable. That does not fit that requirement. If the school is open, as apparently is going to be the case in Florida, and a parent is simply electing not to send their child to school, then arguably they would not be entitled to it. However, if the child has some immunocompromised condition or some healthcare condition, they could very well be able to get some something under the EPSL or something under traditional FMLA if you have 50 or more employees, where they would need to be home to care for the child. That would be unpaid leave under traditional FMLA, and that of course only applies to a nonprofit that would have 50 or more than 50 employees, 50 or more employees. And I suspect that the Department of Labor is going to issue guidance on this, but right now, the way the regulation is worded, unless the facility is closed or unavailable due to COVID-19, it would not be a qualifying basis for the leave.
Thank you, Karen. So another question is, if an employee attends a family function like a family reunion and subsequently claims a potential exposure, gets tested, and is negative, does COVID-19 sick leave apply? I think that it may have been that if they test positive, that might have been the question.
Okay, well, no, it would actually apply. So go down here to number 3. On the emergency paid sick leave, the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis, or the employee has been advised to self-quarantine by a healthcare provider due to having been exposed. So in those 2 circumstances, the person would be entitled to emergency paid sick leave. Now, once they got their diagnosis that it wasn't anything, they're not entitled to it anymore.
Thank you. Let's see. Another question is, should an employer directly ask their employees if they intend to keep their children home from school?
Well, if you need to do so for planning purposes, there's nothing wrong with that. I mean, as a business, you're trying to plan ahead. So what are they going to do with the information, I guess, is my question. I'm assuming that they're going to try to figure out how to plan who's going to be present and who's not. But yeah, for planning purposes, there's no reason you can't ask that. You're not asking people if they're going to have children or get pregnant. You're asking them for planning purposes. You have kids, school resumes August 10th. Will you be able to work? I think what you should ask is not what are your plans for your children, but will you be able to work your regular shift, assuming that people do not telework?
Okay, the last question I have in the chat box, and we have a few more minutes if people want to continue adding some questions, is, are you saying that parents who elect a virtual option versus in person are not covered by the extended FMLA?
The current wording of the expanded FMLA is that you are eligible if the employee is unable to work or telework due to the child to care for a child whose school or child care provider is closed or unavailable for reasons related to COVID-19. That's the wording. So if the school is not closed, unless we have some kind of amendment or some change in the regulations from the Department of Labor or some court ruling that says that that's invalid, that is indeed the case. If your school is open, you will not be entitled to expanded FMLA leave, as the statute is currently written, or should not be. Let me just say you should not be. Some judge may disagree with me somewhere, but that would be the way the statute is worded. You are not entitled to that unless your school or child care provider is closed or unavailable.
I don't see any additional questions coming in. Do you have any last comments to share, Karen?
Again, my bottom line comment is this: follow federal, state, and local guidance. Adopt a COVID-19 plan, identify a COVID-19 monitor, let people know who it is, be sure you don't retaliate against people who complain, address their concerns. I think we're all in this together, and we need to encourage everybody to really do their part to stop the spread of COVID-19 so we can bring these numbers down and hopefully get back to normal sometime in the not too distant future. So thank you all so much for your time and attention. I'm going to send my presentation to Karina, and the Nonprofit Leadership Center will make sure that it gets out to you all. Right, Karina?
Absolutely. Thank you again, Karen, so much for sharing this incredibly informative and timely presentation. Thank you to everyone that participated today, and we'll be sharing the recording and presentation. Please reach out to us if you have any questions, and keep your eyes out for upcoming webinars.
Thank you.